All right, we're on. The defendants are present, represented by counsel. The plan for the day is to try to get through motions and get the case into a posture where we are ready to go ahead and move into the openings and evidence. The plan today for the court is to start moving through some of the motions that have been filed subsequent to our last motions hearing, and then address any other miscellaneous matters that maybe I missed during that process. And then, depending on when we get done with that, give everybody an opportunity to figure out exactly what they need to figure out in the courtroom itself so that we don't have any issues getting started tomorrow morning. So that generally is the plan. With that being the case, anything from the state?
No, Your Honor, nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
We're ready.
From Mr. Bryan?
Nothing, Your Honor.
All right. The way I have this ordered is I've got the outstanding states motions, outstanding McMichael motions, and then I have a list of motions from Mr. Bryan. I don't think we've had anything formally submitted to the court since the last motion here, but we've addressed a number of things on the record. I just don't show anything on my list formally.
We filed a motion to amend it yesterday.
The court's already ruled on that.
And I've already ruled, yes. Okay. We may be 24 hours behind on this list, but yes. Okay. I just want to make sure that there wasn't something else out there that I was missing.
I was hoping to file a whole
Bunch of motions this morning, it just didn't work out. To be fair, Your Honor, when I can get there, we will file a motion for reconsideration of the special demur as to count 7, the aggravated assault with motor vehicle count. We're troubled by it, but we're not quite there yet.
All right. Now, beginning with the state's motions that I have. All right, the last matter that we addressed at the prior motion hearing was 4.67, and now I'm looking at motions in limine. The next motion in limine I have from the state, 4.68, is the state's motion in limine to exclude Travis McMichael's use of force actually, it's the McMichaels generally, I think, use of force experts.
You know, we joined their request to use that expert.
Okay, we'll go ahead. Yeah, it's the state's motion. And let me go ahead and address that. I think the way we did it last time is that we just formally on the record, if you're adopting the motion, that we said we'd go ahead and just take that on the record as we got through the motions, and we'll do the same thing here, as opposed to a uniform adoption.
Agreed.
Okay. All right, from the state.
Thank you, Judge. So, Judge, on August 25th, 2021, the state filed 4.68, the state's motion in limine to exclude the defendant's use of force experts. We were given the defense's witness list, and it included Mr. Key and Mr. Register as potential experts in use of force. And when we actually called Mr. Key, he was willing to speak with us, and his statement to us was, well, I've taught at Flexi, but I'm not Georgia law, a Georgia law enforcement officer. I'm from Baltimore. And he kind of generally outlined what he was going to say, but he said that he wanted to be in court to hear what Travis testified to, so he'd know exactly what Travis was going to say his training was, so that he could then explain that training to the jury. And so that's our understanding of what's going on. And that is also confirmed by defendant's response from October 17th. And the reason the state is filing this motion to exclude any use of force experts is because the defense has put up citizen's arrest and self-defense as their defenses. At the time of this incident, no one, not Greg McMichael, Travis McMichael, or Mr. Bryan, were post-certified law enforcement officers. Travis McMichael had previously been in the Coast Guard but had been out for years. Greg McMichael had lost his post-certification in 2018, and Mr. Bryan had never been in law enforcement. So no law enforcement officers were actually involved in any of the events that led up to this indictment or the death of Mr. Arbery. And therefore, having someone come in and testify to law enforcement's use of force is basically a bolstering situation and misleading and confusing to the jury. Basically, it's going to be confusing and highly prejudicial because it's irrelevant. It's going to incorrectly let the jurors think that this was a legitimate citizen's arrest because we're talking about use of force during an arrest. But that use of force during an arrest by a law enforcement officer is a completely different standard because a law enforcement officer has three things. Number one, he is in uniform and has a body cam usually these days and a marked patrol car. He is employed, meaning there's something for him to lose or for her to lose if for some reason she violates the use of force policy, namely a salary and a job. And that officer has been trained on the standard operating procedures for that particular police department, has training on that policy, has training in that department's policy of use of force and the consequences for what not following that policy, what those consequences are. None of that applies to any of these defendants. None of them were law enforcement officers. Nobody was employed by a law enforcement agency. So we don't have any of those elements in this case. The reason this would be really highly prejudicial is because it doesn't go to any issue in this case. The state will cite to State versus Copeland, 310 Georgia 345. This was a 2020 case. And in that case, the Georgia Supreme Court held that law enforcement officers who are seeking immunity, basically self-defense in an immunity motion in advance, are subject to the same exact self-defense standard as a private citizen. In other words, you have to be reasonably in fear of receiving serious bodily injury or death before you ever use lethal force. And that force used must have been based on the defendants, whether they're law enforcement or whether they are a private citizen, their reasonable belief that such threat or force is necessary for self-defense. So inserting use of force in all the standards and explaining to the jury at Flexi this is what we train law enforcement officers has absolutely nothing to do with this standard from Copeland. I also cite to Kilpatrick versus the state, 308 Georgia 194, also a 2020 case from our Georgia Supreme Court. There they found it was not an abuse of discretion when the trial court refused to allow the expert to testify because it did not believe the expert's testimony about use of force, fight, flight, freeze responses, and human physiology during high stress and life-threatening situations would be helpful to the jury. And the reason is because self-defense is not outside the ken of an average layperson. No one needs to explain self-defense to an average juror. The law is very, very clear that the use of force, the force used, must have been based on the defendant's reasonable belief that such threat or force was necessary to defend himself. Prior training, or even lack of training, has absolutely nothing to do with that reasonable use of force. Therefore, the expert's testimony would be irrelevant under 401. It would be confusing, misleading, and of course highly prejudicial to the state. Because having a use of force expert come in and go, well, I'm law enforcement, I taught at Flexi, I know all these things, I'm going to explain the training these men had in use of force, it actually implies that they were entitled to basically make an arrest and that they were acting somehow in the capacity as law enforcement officers because they had some sort of previous training in use of force. Now, the state's not suggesting that if Greg McMichael takes the stand or Travis McMichael takes the stand that they can't talk all about what they knew, when they knew it, and what training they'd had, what year it was, what they'd been taught, how that affected what they were doing to explain their actions to the jury. That's perfectly acceptable. But you can't have an expert come in if they don't take the stand and go, well, my understanding based on some records are they had this training and this is the training they had, because it's not relevant and it's bolstering that particular defendant's position. And the defense's response to this is exactly what we're talking about. The problem with the defense's response here, Judge, is they've conflated objective and subjective. They first assert that the defendant's belief in the necessity of using force must be reasonable. The actions must have been motivated by the fears of a reasonable man. A reasonable man is also a reasonable woman. So what we need to do is look at this from the perspective of, and I'm just going to randomly pick somebody, a 50-year-old Asian female. Okay? So what's reasonable for her has to also be reasonable for them. And if she's never had use of force training, it's still the standard of reasonableness. The defendants, however, here conflate it by then saying jurors are permitted to consider how a reasonable person in defendant's particular circumstances would react. That's subjective. That's a subjective standard. Now, they're allowed to go ahead and explain this in order to go ahead, the defendants can take the stand and explain this and go, well, this is why it was reasonable for me personally, but to have an expert take the stand in order to bolster, without them testifying it was reasonable, or even if they did testify, to say, oh yes, this was reasonable because they had this training, we're now on a subjective standard. The defense say they're basically saying the jury will hear evidence regarding Mr. McMichael's training and experience while he was in the United States Coast Guard. Not sure how that's going to come in except through Travis McMichael, because such training and experience is not relevant at all for the reasonable man standard. He can testify about his training, but for him to be held to the reasonable man standard, it's anybody. It is against this background that the defense intends to call a retired federal law enforcement officer to explain the concepts that Mr. McMichael knew, relied on, and employed on February 23rd. That's strictly bolstering what Mr. McMichael would testify to. Travis McMichael takes the stand, he can talk all about what he knew in his training. And the problem is, if he gets up on the stand and says, well, I got trained in use of force, gets off the stand, then this expert gets up and goes, well, here's what he was trained, and then explains it in minute detail. That's bolstering, because it's not saying what Travis McMichael had in his head specifically. He's the only one who can talk about that. It's now explaining back in the day, however many years ago, he got some training, and this is what the training was. I'm going to explain it to the jury. The defense goes on to say, use of force continuum, perception reaction time, de-escalation techniques, restraints on the use of deadly force, weapon retention techniques, the ability of an unarmed person to inflict serious bodily injury and to continue to inflict injury even when injured. And then we have the determination of probable cause. Well, you're going to explain the law to this jury. And probable cause is a law enforcement standard, not a standard for the defendants in this case. And the reason that the state has serious concerns about the determination of probable cause is that's a jury charge. That's something that's going to be explained from the court, not from an expert in use of force. Obviously, the state, if the defendants want to get up there and basically say, oh yeah, I determined I had probable cause, then that's an avenue that they can do, and the state will cross-examine them on that. The defense then goes on to say expert testimony on issues to be decided by the jury, even the ultimate issue, is admissible where the expert's conclusion is one of which the jurors would not ordinarily be able to draw from themselves. They concede that experts are only required when it's a conclusion that is beyond the ken of the average layman. Jurors are asked to determine the reasonableness of self-defense claims all the time without expert testimony. This case is absolutely no different. It's not outside the ken of the average layperson. Basically, at this point, the defense claims that they want this expert to educate the jury on the aforementioned concepts at issue in this case. concepts at issue. None of these concepts are at issue in this case. Travis McMichael takes a stand and talks about his training. He gets cross-examined about his training. Those concepts, I guess, are use of force continuum, perception, reaction, weapon retention techniques. Travis McMichael can talk all day long about what he knew and was in his head at the time, but none of those concepts are in dispute. He's just subject to cross-examination. They want to educate the jury on concepts taught at Flexi. Well, that's not relevant. And concepts that inform Mr. McMichael's decision-making. There's no need to have an expert educate the jury about what was in Mr. McMichael's head. Mr. McMichael's the one who needs to do that. And then how Mr. McMichael's actions were consistent with his training. In other words, they want this expert to get up here and go, yeah, everything he did was okay. He's allowed to go ahead and do this because he was trained. That would bolster this, and it's not outside the ken of the average layperson to determine whether what Travis McMichael did was reasonable or not reasonable under the circumstances. This is, of course, very troubling. Mr. McMichael's expert will educate the jury on what Travis McMichael was taught about the guardrails imposed on law enforcement officers by the Fourth Amendment. Once again, no one here is a law enforcement officer. The expert's testimony about Travis McMichael's implementation of his law enforcement training. Well, he can go ahead and discuss that, but once again, this bolsters this concept of citizen's arrest in the minds of the jurors by implying that he was acting as a law enforcement officer at this particular time when he was in no way hired, retained, acting in the capacity as any sort of law enforcement officer. As we all know, he was employed at Metzen Marine at the time, not with any law enforcement agency. And they then claim it will assist the jury to assess whether Mr. McMichael's actions and beliefs were objectively reasonable, not outside the ken of the average layperson. And this idea that an expert should come in here to bolster his subjective reasonableness, the state objects to that. Your Honor, in addition, I believe I emailed your office and provided the defense with the state Cantrell versus the state. If you do not have a copy, I have an extra one right here. Thank you.
When did you email that?
I emailed it to you guys about 3 weeks ago. So I apologize, I only gave you 2 copies. It's Cantrell versus the state. It is from August 12th of 2021, so it's A21, A0773. It's a Court of Appeals decision. And in this case, the defendant Cantrell had been convicted of 3 counts of child molestation and 1 count of aggravated sexual battery. So the underlying facts are different, but Cantrell contended that the trial court erred in restricting his cross-examination of the forensic interviewer. And basically, the court said the permissible scope of cross-examination is committed to the sound discretion of the trial court. Georgia law forbids expert opinion testimony that implicitly goes to the ultimate issue to be decided by the jury when such issue is not beyond the ken of the average juror. So in this particular case, what we had is we had a teenage girl who didn't want to live with mom and dad anymore because she was being, I think it was mom and stepdad, because stepdad was molesting her and she wanted out. The defense's argument was she just wanted to be free of mom and stepdad, and they wanted this expert to be cross-examined on this whole issue of, well, isn't it possible that she's just an ornery teenager who didn't want to live with her mom and stepdad? And that is not a concept outside the ken of the average layperson, that teenagers might not like mom and dad, and that's what the Court of Appeals held. An expert may not testify as to his opinion as to the existence or not of a fact unless the inference to be drawn from the facts and evidence is beyond the ken of the jurors. That is, unless the jurors, for want of specialized knowledge, skill, or experience, are incapable of drawing from facts and evidence such inference for themselves. Self-defense is totally within the jurors' ability to draw inferences from the facts and evidence. Do it all the time. Jurors do not need specialized knowledge. They don't need skill or experience to keep them from drawing a conclusion from the facts in this case as to whether Travis McMichael, Greg McMichael, and defendant Bryan were acting in the capacity of self-defense. where the path from evidence to conclusion is not shrouded in the mystery of professional skill or knowledge. That sort of special skill and knowledge is when you have a firearms examiner, when you have a medical examiner, where you put up that kind of specialized skill that the jurors are not going to have. The conclusion determines the ultimate issue of fact in a case. The jury must make the journey from evidence to conclusion without the aid of expert testimony. So there's absolutely no reason for expert testimony on use of force when no one was a law enforcement officer here. They then cited to the Harris case, and they noted here that the jury heard ample testimony from the victim and her aunt, and they were subject to cross-examination. In this case, if Travis McMichael takes the stand, the jury's going to hear from him. They're going to be able to judge his reasonableness in these actions if he's claiming self-defense. And once they hear from him, and or maybe his father, Greg McMichael, they will be able to make that decision themselves. The jurors will, because it's not outside the ken of the average layperson. This is why we are motioning based on 401, it's not relevant, and certainly 403, it is far more confusing and prejudicial than it is probative on the issue of Travis McMichael's reasonableness and his claim that he was acting in self-defense. Thank you, Your Honor.
Mr. Rubin.
Thank you.
Your Honor, I do want to be clear about a couple things that the state seems to be under the misimpression of. Number one, we don't intend to offer an expert on the ultimate issue in the case. Did Travis McMichael reasonably believe that deadly force was necessary on February 23rd, 2020? Nor do we intend to offer an expert opinion on whether he properly believed that citizen's arrest was appropriate in detaining Mr. Arbery for the police on that day. But this case is unlike other self-defense cases, and that's why we do believe it's proper to use a use of force expert in this case. It's different because although Travis McMichael was not post-certified, didn't have arrest powers, he'd been trained for 10 years on the very law enforcement techniques that all police officers get. It's not standard operating procedures of a particular police department. These are the national standards set by the U.S. Supreme Court in Tennessee v. Garner and other cases on use of force decision making and when it's appropriate or how it's appropriate in particular situations. So these are standards under the Fourth Amendment search and seizure law that are taught at every police department, both state, local, and federal. Travis McMichael, and I agree with the state on some points. Believe it or not.
Marking the time.
Yeah.
Before the first day.
You may not hear this again. The use of force expert has to be informed about the facts of the case. The use of force expert has to be informed of what Travis McMichael's training was in the United States Coast Guard. So we know, and the state knows exactly how Mr. McMichael was trained, because we all have his records. We all have the lesson plans. We all have the transcripts from Mr. McMichael's tenure in the Coast Guard. That is training and experience, both hands-on training and classroom training, that every federal law enforcement officer goes through. That is also the same training that state officers go through either at their local police academies, or as you heard through voir dire, some go to FLETC to get this training. There's nothing unique about it in terms of police officers. But it does inform the actions of Travis McMichael on February 23rd. You don't just throw away your 10 years of training when you become a private citizen, especially when that training is drilled into the Coast Guardsmen or other agents repeatedly so that it becomes muscle memory. That's the whole point of it. You're not supposed to be thinking out there. You're supposed to be acting on muscle memory. That's how you save your own life and the lives of others. Travis McMichael's training and the video, and Travis McMichael even testifying, would inform an expert on what he did, what he was thinking at the time, what he understood the facts to be, and how he implemented his training on a particular day. Now, this expert is not going to testify that Travis McMichael acted reasonably on February 23rd under the self-defense statute, but it is proper to use an expert to corroborate the information the jury would receive from both the video, where they can see actions, and Travis McMichael's testimony. The state charged, for instance, Travis McMichael with aggravated assault. And they're going to argue that the act of pointing the shotgun as Ahmaud Arbery is rushing him was a crime. I would anticipate the expert to educate the jury on when it is proper to show a weapon, when it is proper to point a weapon, not for the purpose of hurting someone or killing someone, but for the purpose of de-escalating the threat or the violence at issue. The Georgia courts in Bracewell versus State, 2000 case, 243 Georgia Appeals 792, and Dasher v. State, 146 Georgia Appeals 118, a 1978 case, have both held that the jurors are permitted to consider the defendant's particular circumstances in their determination of whether he acted objectively reasonable. These are the factors the jury has to consider. The concepts that an expert would testify to that are the same concepts that Travis was trained with or trained on are outside the ken of the average lay person. No one outside of law enforcement understands de-escalation techniques the way it is taught. No one understands the use of force continuum that police officers have to think through and are trained on how to implement. No average person understands the ability of an unarmed person, which we've heard of repeatedly in this case, the unarmed person's ability to inflict serious bodily injury on an armed person, whether it's a police officer or a citizen. And at that point, Your Honor, it doesn't really matter whether that person is post-certified or just a citizen. They both have the right to use deadly force if they reasonably believe that they are in danger of death or serious bodily injury. OCGA section 24-7-707 says, in all criminal proceedings, the opinions of experts on any question of science, skill, trade, or like questions shall always be admissible. Again, assuming they're beyond the ability of the jurors to to understand those facts for themselves. And I would say in this case, given the amount of training law enforcement officers receive, the years of training and the continuing training year after year that they receive shows the court in and of itself that these are concepts and scenarios that are beyond the understanding of the average layperson. I agree that we would have to lay the proper foundation. This expert can't just come in and look at Travis's training records and testify to what Travis understood or what Travis knew to be true, but that's not what we're doing in this case. This expert, who taught at FLETC for years, continues to teach. And it's not Joe Key, by the way, it's Rick Register. It's a different person who's also on the witness list. Former ATF agent who specialized in teaching use of force decision making, has both met with Travis McMichael, has reviewed the evidence in this case, and has reviewed the training records of Mr. McMichael. Assuming we lay a proper foundation, which we understand, his testimony on the proper use of force in various scenarios, including the ones at issue in this case, would be admissible. If the court has any questions, I'm happy to answer those.
I have a motion to confer with counsel. Your Honor, it appears that Ms. Sonikowski and I are actually in agreement. We might want to write that one down too, in the sense that I think we agree that the rules of force in the context of an arrest are in fact identical, whether the individual is a policeman, a bail bondsman, or a private citizen. And I think that informs the discussion here. I'm surprised, and the reason I specifically wanted to address this, aside from the fact that the court's charge in this case and these motions affect Mr. Bryan, is it seems to me that the testimony proffered by the McMichael defense is relevant because of the state's decision to indict these defendants on malice murder. Now, if the state were simply pursuing an aggravated assault claim or even a felony murder claim, that would be one thing. I think the McMichael defense is correct even on those, but with malice murder, there's no question that this testimony would be admissible. The question with malice murder is the mental state, and whether or not the jury finds that Mr. McMichael can justify an aggravated assault by a misapplication, what the state contends is a misapplication of use of force, it seems to me that in explaining Travis McMichael's mental state and why he did what he did, because why he did what he did becomes the issue on a malice murder charge. He may have been mistaken. He might be guilty of aggravated assault. He could be guilty of felony murder, but as long as there's a malice murder count in this case, then why Travis McMichael does the things he does are incredibly important. And since my client is charged as a party to a crime in that murder, we certainly have a dog in this fight. The training that he received is certainly relevant to a jury's determination of whether he acted with malice. In other words, it gets to his credibility.
Now, if Travis McMichael testifies and he explains what he did and the state doesn't contest it, if they don't challenge it, if they don't go after Travis McMichael's credibility when he tells the jury this is why he did what he did, then that's one thing. But taking a wild leap here and assuming that the state plans to challenge on cross-examination the credibility of Travis McMichael when he gives the reasons why he did what he did, then at that point, that testimony is going to be relevant and it's going to be highly probative on the issue of malice. Your Honor, I'd also note, interestingly, we do disagree. The state just told you that probable cause, and if I got this wrong, someone will correct me. The probable cause is not she said probable cause is a law enforcement standard. It is not a law enforcement standard. Probable cause is the same whether it's a police officer making an arrest, a bail bondsman making an arrest, or a private citizen making an arrest. She's got that completely wrong, and that informs the whole argument here. The probable cause standard is the same. The state wants to make a big deal about talking about objective versus subjective, and that's always a very interesting conversation. The state also contends for the last 18 months that what's in the mind of Ahmaud Arbery doesn't matter. All that matters is what's in the mind of the defendants. Well, when you're looking at it from the defendant's perspective, you might as well put badges and guns and mark police cars for all of them, because from their perspective, when they're trying to conduct an arrest, they're looking at it from that perspective. And the state's whole point for 18 months is what Ahmaud Arbery sees isn't relevant. What's in his mind isn't relevant. It's only what's in the minds of these defendants. So again, I think the state is unintentionally proving Mr. Rubin's point. Your Honor, and again, in closing, I'm not suggesting that the training that Travis McMichael received or didn't receive ultimately makes anything he did that day okay. But it is relevant for a jury to determine malice in this case. And for that reason, if for none of the other reasons offered by Mr. Rubin, that expert testimony should be admitted. Unless the state is willing to concede, and that would be nice to know before opening statements, unless the state is willing to concede the credibility of Travis McMichael on that subject. Because if they're going to challenge it, then it's fair game, and we should all be allowed to talk about it in opening statement. Thank you.
State's motion, any final word?
Yes, Judge. Your Honor, we were handed two names, Charles Key and Rick Register. This is the first time I'm hearing that the person going to be testifying is Rick Register. I have no CV for Mr. Register. I've gone to his website where he offers training classes and then lists, I've had this many years of experience, but I have no way to determine whether he's ever testified before, what cases he's testified in before.
That's a different issue, Judge. That's not on the admissibility of it. They can voir dire him. There's no obligation for me to provide a CV or anything, and I'm happy to, but that's not a different issue.
I'd kind of like to do this to keep everybody from popping up. Let's let everybody finish their thoughts, finish their arguments. If there's a response to it, happy to hear it.
Thank you, Judge. So, back again, I have no CV, wasn't provided that in discovery, was not provided with any report. According to Mr. Rubin, Rick Register'd spoken with Travis McMichael. I believe the state's now entitled to those statements. If he's going to base his opinion and you allow this in, then at that point the state is going to want to know exactly what it is that Travis McMichael said to this expert in order to make his determination of whatever he's going to say. Now this, of course, is if you allow it in, because he said he's talked with Travis, he's reviewed the evidence in this case, and he's reviewed the training records, and he's now going to render some opinion. So those are just the two issues the state has. If this is allowed in, need the CV. If this is allowed in, Mr. Register did not return my phone call when I called him. Mr. Key did. And to know exactly what is going to be in his testimony. Right now, I have no report or any analysis or any statements from Travis to Mr. Register upon which he's basing his opinion. So those are some of the issues the state has with that. And defense counsel brought those up, so I wanted to bring it to the attention of the court. Once again, we're back to bolstering. As Mr. Goff just argued, malice murder, an abandoned and malignant heart. Malice can be formed in an instant. So the state's not contending there's a misapplication of any use of force. The state's contending what the law is that this was unreasonable to pull out a shotgun and start pointing it at somebody who was not a threat at all, but was simply running while being chased by Mr. Bryan in his truck toward a man holding a shotgun. And then he tried to avoid that man. That's what Mr. Arbery did. So this whole idea that we're claiming it's a misapplication of use of force, we're not even talking about use of force. Those are not our words. Those are their words. Why Travis did what Travis did, Travis can take the stand and explain that. And Mr. Goff just made the state's point. They need this expert to bolster his credibility. That's exactly what they're doing here. This is bolstering. Travis McMichael can get up and talk about his training. He can talk about what was in his mind. He can talk about what he was thinking. But then to have an expert come in and go, yes, this is what he was thinking, this is what he was thinking, and let me explain to you how 10 plus years ago or whenever it was, he got some of this training and this is what he was trained on. I didn't train him on it, but this is what we train people on so that the jury understands what he was trained on. Maybe they do, maybe they don't. But Travis McMichael should be able to explain his training. Because here's the other problem, Judge. Memories fade. And while the defense wants to talk about muscle memory and he was acting in the capacity as law enforcement in their minds, well, they can explain that. But the problem is if Travis McMichael takes the stand and says, I was doing A, B, and C, and then Rick Register gets up there and goes, well, he was trained to do A, B, C, D, E, F, G, and H. Well, there's all these things that Travis McMichael didn't testify he did, and now we have Rick Register going, but he was trained in all these extra special other things that Travis McMichael never said that he knew about. And of course, it begs the question as to the preparation of Travis McMichael for his testimony by an expert in use of force. So, Your Honor, once again, no one here was acting as a law enforcement officer. If they want to claim in their minds they were acting as law enforcement officers, they can take the stand and explain that. The use of force expert under 403 is far more confusing and prejudicial than it is probative on the issue in this case. Because Copeland says so. Law enforcement officers are subject to the exact same standard. I mean, this is 2020, the Supreme Court of Georgia. Law enforcement officers are subject to the exact same standard as regular citizens. 50-year-old Asian woman who takes the stand and says, I was acting in self-defense and this is why, her reasonableness is analyzed under the exact same standards by those jurors as someone who comes in here and says, well, I've had law enforcement training and this is why I did what I did and this is why I was acting. An expert to bolster his credibility and an expert to explain his behavior, all it does is bolster the idea that this was a legitimate citizen's arrest, which is, by the way, the state has to prove it wasn't beyond a reasonable doubt. And so the state is very concerned about this, and we ask you to prevent the defense, to grant the motion in limine, to keep an expert in use of force to come in here simply to bolster his credibility and to make it seem as if he was acting as a law enforcement officer. Thank you, Judge.
Can I make 1 or 2 points?
Three very small points. It's interesting that the state says that a law enforcement officer stands in the same shoes as a private citizen, because that's exactly true. And the jury's entitled to know, just as they would if a law enforcement officer was on trial, what training and experience that person, whether they're an Asian woman who has no training, or someone who spent 10 years in the United States Coast Guard who has extensive training in law enforcement techniques. The argument is kind of all over the place for the state. Memories fade. Travis McMichael might not remember his training. Those are all questions for Travis McMichael if he testifies. Those are questions for the expert if he testifies. Those are cross-examination questions. What the state calls bolstering is actually corroboration. Travis McMichael, if he testifies, and testifies to what he was taught in the Coast Guard, can be believed or disbelieved by the jury. But a FLETC teacher who teaches the same exact things and who has reviewed Travis's records and reviewed the video and spoken to Travis McMichael can corroborate the concepts, not what was in Travis McMichael's mind, but the concepts that are taught to everybody who goes through the training that Travis McMichael had. It's not bolstering, it's corroboration. We're entitled to corroborate the testimony of our witnesses through expert testimony. Thank you, Your Honor.
I'll tell you how I normally do it. It's the move-ant, response, and then a rebuttal. So just to make sure the day doesn't expand to 7 to 8 o'clock tonight, I'm going to try to keep to that, but
And Your Honor, given the extra travel distance from my seat to the podium, may I speak from here?
yeah, I can hear you just fine as long as everybody can hear you.
Your Honor, I have 2 points. One is, and I would suggest the court should be offended by the suggestion made, but not personally, as an judicial officer, that the state's burden in this case should somehow change the rules of evidence. Is the state really trying to suggest that the ends justify the means? That because the state has a need that the rules of evidence change? That's not the way I was taught. The state has to live with the rules of evidence as they are. And my second point is, echoing Mr. Rubin, we do this in all kinds of areas of law. This suggestion by the state that there's something unusual or remarkable here about this motion, I think the court should find troubling. When you challenge the credibility of a witness, you open doors. It's not bolstering, it's corroboration. And that's exactly what the state just cites a child molestation case. We deal with these issues in sex cases, sex offense cases, and child molestation all the time. You do this, you do that, you open doors. And again, the state didn't even respond. And I think before the court goes any further, the state needs to put the court needs to put the state on the spot. Do they intend to challenge the credibility of Travis McMichael if he's going to get up there and testify that he acted the way he did based on his training? And whether right or wrong that he didn't have any malice. Is the state, are they conceding they're not going to challenge his credibility? Because if they'll acknowledge that they are, then this conversation becomes real short and real simple for the court.
All right. This motion was filed back on August 25th with the defense responding October 17th with the additional supplemental information that was provided by the state. Considering the record, considering the arguments of counsel, the court is granting the motion in limine to exclude the use of force experts. There's going to be a written order that will provide more detail on the court's ruling, but generally relying upon Kilpatrick, and actually Cantrell, I guess, is more recent than Kilpatrick, but talks about the same things, where jurors can take the same elements and constituent factors which guide the expert to his conclusions, and from them alone make an equally intelligent judgment of their own, then expert opinion testimony is not admissible. That's Kilpatrick, which again is consistent, I think, with Cantrell. Here we're discussing the objective standard that the jury is going to be using in order to evaluate, it sounds like, the defendant's actions, which are on video and evidence will be presented on. At the time that the defendants were acting, they were not specifically acting as a law enforcement officer. They were private citizens who were acting, as I understand the defense will be, a citizen's arrest. The Kilpatrick was a case, I've got it down here in my notes, where the trial court, there was a finding the trial court did not err in excluding a use of force expert's testimony on grounds it would not be helpful for the jury in determining whether there was a justification in shooting. There's also Mosby versus the state, let's see, 296 Southeast 2nd, 277. The Georgia Supreme Court has also previously held that an average juror generally can determine without the aid of an expert whether conduct allegedly taken by an individual in self-defense was necessary to protect against death or great bodily harm. It's also Perry v. State, 295 Georgia App 264, that cites Weems versus State, which is a Supreme Court case from 1997, 268 Georgia 142. And again, as was said by most, law enforcement officers are held to the same self-defense standards as private citizens, and that gets into State versus Copeland, and Kidd versus Coates. All those sites will be available in the court's written order. I do also point out that there's additional support from other jurisdictions, again, obviously not necessarily holding the weight of precedent in this court. Under more similar circumstances, there's some federal cases, Hart v. Howard, use of force expert excluded, where neither party was acting as a law enforcement officer. The altercation was on video, and the expert's testimony would not be helpful to the jury. There's also one out of, the Northern District of Florida, where trial counsel was not ineffective for failing to call a use of force expert under similar circumstances. There's one out of Maryland, use of force expert not allowed to testify to police officer appellant's use of force as a civilian, because whether a civilian used reasonable force is an issue that the jury can decide without the aid of expert testimony. All of that will be contained in the court's order. All right, the next motion, 4.69 is actually the motion regarding the restriction on extrajudicial statements. That has already been addressed. The next one in line, 469, was extrajudicial statements. That's already been addressed. 470 is the state's motion in limine as to THC.
Thank you, Judge. So state's motion in limine as to THC 4.70. The first thing I'd like to tell the court is that the state is not going to tender into evidence either the blood alcohol content via Amanda Cook of Mr. Ahmaud Arbery. It was negative. He had no alcohol in his system, but we are not going to put that evidence up. Just like we are not going to put up any evidence of any drug tests on Mr. Arbery. The drug tests all came back negative the very first time that the GBI did their baseline test for cocaine, amphetamines, THC, everything. It was only when Agent Dial requested a screening of Mr. Arbery's blood to see if he had any prescription medications in it that a minute amount of THC was discovered in his blood. And I apologize. It would be Jim Gordon who would do the BAC, but we're not going to put up his blood alcohol content. So having stated that that's the state's intent, we are not going to discuss what was in Mr. Arbery's system, what wasn't in Mr. Arbery's system. That's not going to be part of the state's case in chief. We learned from speaking with the defense that they did wish to put in his THC, so we filed a motion in limine to go ahead and keep that out, given it was such a minute amount. And when we spoke with Miss Amanda Cook, she said, listen.
There's a couple toxicology reports, so the state's not using any of the toxicology reports?
None of the toxicology reports. Okay. None of them. Not going to put any of it in. They were all negative up until we came up with this minute amount of THC. So we went ahead and filed this motion in limine to keep out this, because when we spoke with Miss Amanda Cook, who is the person who ran the toxicology and discovered the THC, she indicated to us that she couldn't tell us anything about how it affected the victim. I mean, it's THC, part of what's in marijuana. She had no way to determine how it affected Mr. Arbery, what was going to happen with Mr. Arbery if he smoked it, how long ago he smoked it, why it was in his system, when he smoked it. She certainly couldn't tell the quality or quantity of what it was, given, as we all know, marijuana now has marketing value. This one will make you mellow. This one will make you feel this way. She couldn't tell us anything about it. And so the state feels it's not relevant, and we were not going to put it in. In response to this, the defense then filed on October 11th a response to the state's motion. And for the record, the state filed its motion in limine on October 4th of 2021 to limit evidence of the THC in Mr. Arbery's system. October 11th, the defendants filed their response. Their response is that they are going to want to put up an expert, and their expert is the same expert that they were going to put up to go into his mental health. And they basically, with their response, went right back down the rabbit hole of she can come in and she can say what this minute amount of THC did to Mr. Arbery, because she's also going to testify then to the schizoaffective disorder and all of his mental health records, and then she's going to base that opinion and diagnosis was correct because she's looked at all of his other acts. So now we're backdooring, hey, he had minute amount of THC in his system, and here's our expert to explain what effect that had on Mr. Arbery, and our expert's now going to go into a 2018 diagnosis. We're going to go into her supporting that diagnosis with all of his other acts, and that's exactly what they have said in their motion, that's exactly where they're going. We, of course, had no idea they were going to proffer and want this woman to then testify to everything that this court has already excluded and written extensive orders on. The state, of course, cites back to the hearings from May 12th and 13th of this year. And we have, of course, the court's ruling from October 1st of this year on the order on the admission of the victim's mental health records. So, Your Honor, we ask that the THC, because it's such a small amount, be kept out. Once again, they had no idea who Mr. Arbery was. He was a complete stranger. The idea that their expert's going to be able to come in here and put all of that evidence in when the court has already ruled all of it out is just a backdoor way to get that evidence in that the court has already ruled as inadmissible. And we ask that it be excluded, and we are not going to go ahead and proffer it or put up any of the toxicology reports from Mr. Arbery. Thank you, Judge.
Your Honor, before I begin, could I inquire whether the state did share with us that they intended originally to put up the absence of alcohol in the system because alcohol in the system could make somebody combative, and so it was their original intent, and they've obviously changed that, what I hear them saying now, but it was their original intent to introduce the absence of alcohol in Mr. Arbery's system at the time of the shooting to demonstrate to the jury that he didn't have alcohol, which could make him combative.
The answer to that question is no. The state had put I'll back up for a second. The person who originally did the BAC analysis is on maternity leave. So the state went ahead and said, well, will you guys stipulate to this fact? And we did it without really thinking it through. Totally admitted, hey, my witness is unavailable. Will you guys stipulate to this? This is how we can put it in. Will you, meaning you guys, the defense attorneys, stipulate to the fact that his BAC was negative? And we were doing it out of transparency. This is our case. We just want to put this in, being transparent. We then went ahead and found Jim Gordon, the peer reviewer, and we served them with that. And then once the THC thing came to our attention, and I apologize, I thought I had told y'all, meaning defense attorneys, that we had then no intention of putting any of this in, because once we thought about it, and your ruling came out on October 1st about his mental health, none of that became relevant as far as BAC or what was in his system. So we changed it, especially when the defense withdrew their consent to that stipulation. We basically backpedaled, thought about it, and filed this particular motion. So I just want the court to be clear. I hate to admit it, but it was a little, hey, we're being transparent, let's thoughtlessly put this up, will you guys agree to it, without thinking through the implications of it. Once we got your ruling and talked to the defense, that's why we've withdrawn that evidence. We find it not to be relevant in line with the court's ruling, and we're not going to tender any evidence of the BAC and/or the drugs.
I guess my question is that the state informed the defense that they were going to put up the evidence of no blood alcohol because the jury needed to understand there was no alcohol, because the jury could think alcohol, because of the aggressiveness equivalent, that alcohol causes aggression, there's no alcohol, so there was no aggression. And I think that the state needs to admit that to the court, because that was a conversation that we had, that the state recognizes that alcohol could cause aggression, which would make the issue relevant to a jury, but since there is no alcohol, then that was why they wanted to put that into evidence.
Well, let's talk about what the evidence, we're dealing with motions in limine, and so I'm just focused on evidence that is being proposed and what to do if there is anything to do pre-trial.
Okay, I think what's important here, Your Honor, is that the state has shared with the defense that they recognize the relevance of substances in the body.
Objection.
What's the
I
objection?
appreciate this is an objection. I appreciate Mr. Shepard speaking for the state, but that's not at all what the state is saying. So I want on the record, while he's speaking for me, that's not what the state intends at all.
Well, that's why I was inquiring. So let me explain to you why I'm saying what I'm saying, Your Honor. In a conversation with Miss Olivier, the state recognized to the defense that substance in the alleged victim's body at the time of the shooting in the case could go to the potential aggression of the alleged victim at the time of conflict. And their goal was to put into evidence that there was no blood alcohol so that the jury wasn't wondering about it, and to solidify in the mind of the juror that there was no alcohol in Mr. Arbery's system at the time of confrontation, because the jury could think alcohol makes people aggressive, so it would be good for them to know there was no alcohol in the system. I want the court to understand that the state has acknowledged the point I'm about to make, and I think it's important for transparency purposes. That being stated, Your Honor, what we know here is that at the time of the conflict in this case, Mr. Arbery had THC in his system. Now, that is a chemical substance that causes behavior. There are a line of cases that go directly to this issue where the defense can establish a causal connection between that chemical substance in the system of the alleged victim and its potential to cause aggression, to cause confrontational behavior, and to cause combative behavior. That's the beginning. Now, not only do we have evidence that Mr. Arbery had THC in his system at the time of the shooting, the autopsy in this case also confirms that he had what the medical examiner calls anthracotic pigment in his lungs, which is associated with extensive, regular smoking of large amounts of marijuana. The toxicologist also confirmed that the THC in the system also corroborates frequent use of marijuana. So there's no mystery anymore around Mr. Arbery's use of marijuana and that he had it in his system at the time of the shooting. Now, the cases that support the admissibility of this type of evidence go straight to really the ultimate question. Is there any connection? And the language that we find in these cases is the presence of this system in the body could cause aggression, could produce strange behavior, potential behavior at the time of the conflict. Those cases, the McWilliams case, which is a Georgia Supreme Court case, 280 Georgia 724, 2006, the court in that murder case excluded the ME who came in a pretrial hearing and said, you know, I've studied the literature on this issue about cocaine metabolites, and in that case also involved alcohol. Didn't know the issue prior to reading literature on it, but studied the literature and found that those substances could cause aggression, combative behavior. The Robinson versus State case, 272 Georgia 131, talks about that causal connection. Gill versus the State, 296 Georgia Supreme Court 351 2014. Those cases stand for, does the alleged victim have this compound in his system at the time of the fatal encounter, at the time of the homicide? Now, what we know is that he does, but what's the causal connection? Ultimately, Your Honor, we have learned through our psychiatrist that Mr. Arbery has a diagnosis of schizoaffective disorder. I understand the court has ruled this out currently. But schizoaffective disorder, that diagnosis by Gateway, the same institution that this court, not Your Honor, but Glenn County turns to time and time again for diagnosis of people in the criminal justice system, diagnosed Mr. Arbery with schizoaffective disorder late in 2018, early 2019. Our expert has reviewed more information than that expert at Gateway had and concludes that that is an accurate diagnosis, and understands through literature and through her experience, this is Dr. Kelly Kaufman, that an individual specifically with schizoaffective disorder who uses THC has a higher incidence of aggression, that THC in particular, used by an individual with schizoaffective disorder, exhibits aggression. It's documented in the literature, it's understood in the community, and understood by our expert. So, the question for the court then becomes, does he have the compound in his system? Yes. Is there corroborating evidence that he has chronic use, excessive use of THC? Yes. Is it in his system at the time of the homicide, as Robinson stated? Is it in his system at the time of the fatal encounter, as Gill has stated? Is it in his system at the time of the shooting in McWilliams? Yes, it is. Now the question becomes, could it cause potentially aggressive behavior, combative behavior, confrontational behavior? Yes. The expert says yes. Now the state can cross-examine the expert. The state can say, you don't really know. That's weight. But it is reversible error, as McWilliams has held. New trial, to not allow this evidence to come in. Thank you, Your Honor.
Final word from the state.
Yes, Judge. Unfortunately, I'm unprepared to rebut Mr. Shepard's assertion that McWilliams holds as reversible error not to let any of this in, because we heard a lot of could it potentially do this, and potential behavior at the time of conflict, and is there a connection between a minute amount of marijuana that could cause aggression? And we're right back down the rabbit hole that this court has already been down with the mental health and the 404B. In this particular case, why Mr. Arbery did anything Mr. Arbery did is completely irrelevant. That's not the question. It's what the defendants did. And they knew nothing about this. They knew nothing about what was in his system. And we're going to do our 403 again, where we go down the rabbit hole with Kelly Kaufman, because she's going to take the stand. She's going to then start talking all about his medical diagnosis. She's going to talk about it. And right now, Judge, you have ruled that the medical diagnosis is, from 2018, suspect at best. She never met Mr. Arbery. She never interviewed him. And she's going to look at the 10 worst moments of his life with the 404B evidence and basically go, okay, yeah, this is him. And therefore, I conclude these things. It's under 403, very, very prejudicial, and the prejudice outweighs any probative value with the fact that I don't even know if this is consistent. Frequent use of marijuana. Whether there's the stuff in his lungs means only marijuana. And they're talking about it causing him to be aggressive, combative, and confrontational. That is for the jury to decide. This is on video, and they can determine it. Dr. Kelly Kaufman's testimony on the effects of THC on Mr. Arbery are not relevant, and for the same grounds her testimony would not be allowed for his mental health, those are the exact same grounds that this court should find it's not relevant to her to talk about THC in his system. We ask that based on 401 and 403, and for the exact same reasons the court has already found in excluding evidence of his prior acts and his mental health diagnosis, that you deny this motion. Because at this point, those two rulings will go right out the window with Dr. Kelly Kaufman taking the stand, and we're going to go through all of that evidence. And at this point in time, the state would, of course, want to put up an expert to rebut this. And we end up with our mini trial within a trial again. So we ask that you exclude the THC evidence. The state will not be putting any of that in, and will not be putting any toxicology BAC in, and will not be asking the medical examiner about those reports. Thank you, Judge.
I don't want to restate my position, Your Honor, but I would like to address the mini trial. We don't need a mini trial on this, Your Honor. The defendant needs a fair trial, though. He's entitled to that. And for her to come up and say he has a diagnosis and that THC use by a person with that diagnosis does not create a mini trial. It creates a cross-examination. The state is threatening the court with a mini trial.
I'm hearing from both sides. You're
No,
throwing out.
I'm not saying
Let me
you're-
direct you to your statement that said basically what McWilliams says. If I decide something different than what you just said, that's reversible error.
It is.
Listen, stick to your arguments.
Sure.
I'll listen to them. But let's not talk about either side threatening the court with whatever may occur. You all are advocates. Go ahead and advocate your position.
We gave the state our brief on this issue with McWilliams cited in the brief. State's had plenty of time.
All right, there are really two separate things that were just raised, one of which actually I don't think is briefed. The first is the issue that's brought up by Dr. Kelly Kaufman's potential appearance in this case. So let's address that first. Defense had filed a response to the state's motion in limine, addressing specifically the second toxicology report. Wanted to demonstrate that the presence of THC in the absence of Zyprexa, I think I'm pronouncing that correctly. You are. Talking about that. Now, that theory of admissibility derives itself from the gateway diagnosis. And there's no way to get past that, because it talks about, effectively the testimony, we talk about the combined effect of THC and Zyprexa. The gateway records have been excluded, and the court finds that the defense theories flowing from those gateways, or from the gateway diagnosis, would be inadmissible. I've written down what Dr. Kaufman was going to testify to. That's in the record, I think was repeated accurately here. I did, in my notes, put in that, at least based on where I thought we were with this before argument, that really the thought-provoking side of this is this theory that is out there about alcohol and the lack of alcohol. What I'm hearing is that the state doesn't intend to go down that road, so that is not something the court's going to need to address, understanding that that is not an issue in the case. The other part of this, which I think I heard the defense argue, is that somehow the THC is just relevant on its own.
No.
Okay, I just want to make sure I was clear about that. I thought I heard a second argument in there.
No, it's not. It's relevant with Dr. Kaufman's findings. The Gateway records, Your Honor, are documents of statements by Mr. Arbery. They're also observations made. The conclusion of his diagnosis, that may be by the RN and the PRN there at Gateway, but those records are a repository of observations and statements made by Mr. Arbery and then taken into consideration by Dr. Kaufman. The court has not allowed us to put up Dr. Kaufman yet. We have tried to summarize for the court, but we still intended to make a record through Dr. Kaufman of why she came to her independent diagnosis. So to say that you've already found that the diagnosis made by the nurse at Gateway now would preclude it, we would say to Your Honor, you need to still hear from Dr. Kaufman. She has much more education, much more information than the folks at Gateway did, and her diagnosis is firm. And so, but it would be, Your Honor, as Your Honor's pointing out, it's not just the presence of THC. It's unique to a person who's been diagnosed.
The court issued an extensive order on the mental health records, the Gateway records. And to me, this is an additional layer to that. Based on the court's prior findings and my understanding of what this particular evidence would be used for, that motion to eliminate is granted. I may have reversed on the use of force. I think I said it was, the motion was denied. I'm reversing myself here. It's granted. It's the state's motion. So just to clarify the record on 4.68.
Is the court going to prevent us from getting into the autopsy and the findings of the autopsy and the results of the lab tests that were done? I understand the state's motion in limine is about that THC can cause aggressive behavior, etc. Is the court going to prevent us from asking about the full autopsy that was conducted and all the findings of the autopsy, included that toxicology was ordered and all of that, based on what the medical examiner did?
That's why I was asking whether or not that's the second part of that argument that I thought I heard.
Yeah. No, we're not arguing that the presence of THC in of itself has a factor to aggressiveness.
Well, no, that wasn't what that the presence of THC is relevant in some way to this case. That was the second argument that I was referring to.
Yeah, I understand. I understand what you're asking. I'm just asking, are we allowed to get into all that was conducted to the autopsy, that they did a toxicology, that they sought that kind of information, or is the court going to prevent us from asking any questions about findings in the lungs or doing toxicology?
What I understand is that the level of THC in the toxicology report is, and my brain's not working right now, but it is, there's no expert, nobody that can explain what that level, what is it, 0.3 or 3 nanograms per milliliter, whatever the number is, what that means or what it is.
Except for our expert.
Okay. Your expert's going to come in, but your expert, you're saying they're coming in to testify that that amount, when combined with the lack of another drug in somebody in the mental state that she has decided forensically he was in, it has some sort of potential effect.
Yeah, the presence of THC.
And that's what I've ruled on, is that's not all coming in.
I understand.
Okay. Now, the second level, which is the second argument that I was asking about really, is, so the THC is out there. I understand nobody's at this point able to come in to say that that has any known effect at that level in this particular individual. Is that a fair?
Absent the connection to mental illness, right. Yeah, there's not an expert that we're going to present that would say, at this level, in just a typical person, it could cause aggression.
So
That's correct.
what I need to think through, and I'll take under advisement, because what I understand the question really to be then is, if we go through the autopsy and the toxicology reports are out there and it shows that there's this THC, is the court not going to permit the toxicology report in that has that level? I guess that depends in part on what position anybody's taking on it.
Or the absence of medication. I mean, these are things that were investigated. There's a reason that the medical examiner's office investigated this, Your Honor. There's a reason that they wanted to understand this, but the court is going to be shutting us down because these medical... Yes, sir.
Okay, the court's ruled on the mental health side of it. From what I understand, the GBI was interested in the issue, and so they followed up. That doesn't necessarily mean that it's relevant at trial. This was the follow-up. So a second toxicology report was done, showed an absence of a particular drug, and because it was from what I understand from the briefing, a more involved, it brought up a small amount of THC. I don't know what that small amount of THC means. So maybe before I get to the point where I make a decision about the toxicology report, someone can educate me about what, if anything, that means. And if it doesn't mean anything, and what ends up happening at trial is I end up hearing arguments to the jury, well, there was this, it's marijuana in the system, and it becomes an issue in the case. I've got to take all of that into consideration. That gets back into 401 and 403, which gets back to my point is, I think I did hear the second argument, which is we kind of want that THC number to be there. We want the toxicology report to come in because it's part of the autopsy.
Well, I also, we're not trying to seek evidence for admissible purposes, but here's one of the issues that I'm asking about now. The medical examiner has an interest in understanding what happened at the time of conflict and dives down into the body of the decedent to understand what could have led to the conflict. The court has said, I'm not letting in evidence that this young man had a mental illness or was diagnosed as such. The medical examiner was interested in that.
Well, I understand from the briefing that Richard Dahl was interested in that. He asked for the second toxicology report. He's not the medical examiner.
No, we've talked to the medical examiner. The medical examiner has an interest in understanding whether this gentleman was on medications or not.
Stop for a second. I'm not going to go further down here.
Okay.
The medical examiner in the original autopsy didn't do this. He was asked for the second toxicology report. He could have.
Yeah.
And if he's not the individual that requested it, he didn't. There's now the
I'm
report.
talking about Zyprexa as well. He asked for
Stop for a second.
Zyprexa.
I've already ruled upon the first part of this.
Okay.
That's not coming in.
So I
The
guess what we
second
would
part-
need to do, I'm sorry. I understand the court's ruling.
I've already said, the second part of it is, apparently, we're going to run into some debate about this toxicology report.
Right.
I guess the first thing to do is let's talk about it, because I don't even know if it's coming in. I don't know who's going to get it in. And then if there's an issue there, I'll see if I can address it.
Okay.
But this is a motion in limine. The motion in limine was specifically related, as I understood,
Right.
to this expert's opinion that touches upon some of these gateway records. I've ruled on that. That motion was granted.
I understand that very clearly.
Thank
So
you,
my
Judge.
point of inquiry was whether we'll be allowed to dive deeper into the autopsy and things that the medical examiner was interested in, like the gateway records, like the Zyprexa or absence of medication for the diagnosis. Those things, if and the court is essentially saying, no, we're not going to let you talk with the medical examiner in front of the jury about the medical examiner's interest in understanding those issues for the purpose of trying to make a conclusion during the course of the autopsy, then we just would need to make a record of that with the medical examiner. And perhaps it'll become more relevant at that time and the court would change its mind on prior rulings. But I think I understand you're going to prevent us from going into toxicology. You're going to prevent us from talking about corroboration of THC use, excessive THC, unless perhaps we can come back and educate the court on THC use in of itself causing aggressive behavior, confrontational behavior, outside and isolated from mental illness diagnosis.
I've
That was
ruled.
my question to the court, and I think we've...
The
worked
court's
it out.
ruled. The court granted the motion in limine. So at
That
this,
was for that one issue, but we're also talking about other things that were done, so I thought I'd bring it up.
I would caution counsel, the court has ruled, made very clear in a very long order,
Right.
looking at 401 and 403, other relevant statutes and case law, where the court is on the gateway records and the mental health diagnosis. I would suggest that's a starting point to educate counsel on where the court is on those records. I've also now ruled that this other way of getting to the records, which is through the testimony of a lack of substance and presence of a small amount of THC, that's out. That's not another way that the defense is going to use to get to the gateway records. The court has an extensive order on the matter.
It's just a separate issue. It's not another way to get to backdoor. This is a separate issue dealing with aggression and primary aggression. That's all we're trying to make a record of, Your Honor. I understand the court's order.
All right. Well, let's go ahead. Let's just go ahead and take a 10-minute recess. The next matter I have is 4.71, this motion eliminated from the state regarding probation. Probation. Please be seated. All right, we are back on. Defendants present, represented by counsel. We'll keep moving through the various motions. The next one I have, as I mentioned, is the motion labeled 4.71, State's motion in limine regarding probation from the State.
Thank you, Judge. Came to the State's attention via conversations with defense counsel that defense counsel wished to just have the State stipulate that Mr. Arbery was on probation, not what he was on probation for, but that he was on probation at the time of this incident. And Mr. Rubin and I had a discussion about that, and I'm sure that they will correct me if I get this wrong, but my understanding is that they wish to put up evidence of his status on probation as to go to what he was thinking. In other words, he knew he was on probation, so when Mr. Albenze saw him and he's on the phone under the tree across the street calling 911, that Mr. Arbery somehow saw Mr. Albenze, and that Mr. Arbery's thought process was, hey, I'm on probation, I'm in a house I'm not supposed to be in, it's open, it's under construction, but some guy's across the street on the phone, and because I'm on probation, I need to run away. And that's why he takes off running very, very fast down the street into the neighborhood, not out of the neighborhood, but further into the neighborhood. And then again, that he chooses potentially to, as the defense keeps saying, attack Travis McMichael because he knew the police somehow were on their way, potentially, not sure, given no one in this case has ESP or the ability to read minds, but somehow he knew the police were on the way because he saw Mr. Albenze on the phone, and because he's on probation, as opposed to getting arrested by the incoming police officers for probation, he's going to engage in an altercation with a guy with a shotgun. And that because of his probation status, that would be the actions that he would take. By the court's prior order on 404B other acts. And his status as a probationer was excluded with that order. However, Your Honor, I went back and looked at the order, the complete order, and there's actually nothing that specifically addresses his status as a probationer, because the order was about his other acts, and I don't believe when I looked back at the order there was anything that said his status as a probationer is excluded. The State assumed that his status as a probationer would fall under the rubric of the exclusion of the 404B other acts evidence. However, it isn't there. So that's why the State, out of an abundance of caution, wanted to bring this to the court's attention and request that the evidence that Mr. Arbery was on probation at the time of the homicide be excluded, as it's impermissible character evidence that doesn't fall under Rule 401, relevancy, and it would violate, in the State's opinion, Rule 403, as it's far more prejudicial than probative, because we're back, according to the defense's motion. Judge, this morning I received an additional motion from the defense that also kind of addresses this. But what they're saying is there's alternative explanations for why Mr. Arbery did what he did, and we're entitled to explore what he was thinking. Even though he's deceased and can't defend himself and can't tell us what he was thinking, we're going to speculate as to the fact that he knew he was on probation, so therefore he must have been thinking, I'm about to get arrested for a probation violation, because that's what's going on and that's why I'm running away. So that's really what the defense's response here is that the court should deny our motion, basically based on they're claiming that it's not being offered for an impermissible character purpose because the evidence is relevant to the theory of the defense. Well, the theory of the defense is they were making a citizen's arrest, and the theory of the defense is that they had to act in self-defense. Mr. Arbery's thought process, once again, completely speculative, as to what he was thinking and why he chose to do what he did, goes right back into this speculation situation of, well, he was on probation, he knew that, so he probably took those actions based on a desire to not have his probation violated, all of which there is no underlying evidence for because Mr. Arbery's deceased and we can't ask him, and he never made a statement about that. We can't get to Mr. Arbery to say, Well, were you thinking you were on probation? Is that why you were running away? Oh, is probation the first foremost thing in your mind? So that is the problem. They cite to some res gestae, which of course, as you know, is inapplicable here. That concept of res gestae is out. It's hearsay under the first parts of Part 1, 2, and 3 under 804.
You're talking about Thomas and Mills?
Yes.
Those cases.
Right. And the McMichaels show that Mr. Arbery's probationary status on February 23rd is admissible because it's intrinsic to and inextricably intertwined with the events that took place on that day. Once again, the state will just restate its argument that it made with the 404B hearing, that it has absolutely nothing to do with their defenses, and his status as a probationer has absolutely nothing to do with what he did on that particular day. It would be speculation to go into what he was thinking based on his status as a probationer. And at that point in time, Judge, we ask that this fall under the same heading as the other act's evidence, and that you exclude any evidence that he was on probation. Thank you.
Your Honor, Mr. Sheffield and I are going to tag team this one because we have different responses. And I'm going to start at the end, and he'll come in and go back to the earlier response we made to State's 4.71 motion in limine regarding probation. In that one-page motion, they say in the third paragraph that the defendant's true intended use of the victim's other acts was to engage in speculation as to why Mr. Arbery acted as he did. And just this morning, and I don't know if anybody's had time to read it or absorb it, I filed a what I would call a supplement to our response, I suppose, and that's the only part I'm going to talk about, and then Mr. Sheffield I'll tap out and he'll take the first part. I can give you one. I emailed one to Your Honor this morning, or yeah, maybe this morning or last night, but I think I've got an extra one.
I apologize. I have no idea what Mr. Hood's talking about.
Okay.
Well, I emailed it in response to an email from the state, and Ms. Dunikoski's email gave me an auto response that you were out of the office, which I am aware you are here in the same room with me, but I didn't know how else to email her back. Her email came to me, so you've got an auto response thing set up on yours, I guess.
Okay, just so that we're clear then, what I understand is we're about to argue something that was filed. I haven't printed it out, so let me look in my email.
Well, and I can say this, I mean, we can argue it, it's pretty simple, really. I mean, I don't even need to have filed anything, actually.
So, 8:09 this morning is when it looks like it came into my office.
Right.
Okay.
I finished writing it this morning. But it's just it's not even a required motion. It just supplements what we'd already filed. And my stating here in just a moment what's the substance of it will be sufficient for everybody to follow and track the argument. Because here it is. I go back to the state's motion, and they say that they think that our true intended use of Mr. Arbery's probation status on February 23, 2020. And Your Honor, if you like, I'll wait and not talk until you've had a chance to read it.
I mean, let's get it on the record. Go ahead. It's not as simple as that.
I can do either. I can state it, or I can wait and let everybody read it and then state it. But I would like to argue it with everybody's full attention.
Was there a reason that we waited until now to do this?
I didn't have to file it at all. I could have made an objection or done it at trial. This is a courtesy, actually. I think it's to help.
It's not a courtesy of the court to email an argument at 8:09 in the morning and then expect us to get up to speed with it, including not assuming the state, let's just be clear about it, particularly while we're in trial here. Just because you send something at 11 o'clock at night doesn't mean that everybody's going to have an opportunity to read and digest it, and that applies to both sides. I've gotten a number of things late at night or first thing in the morning. I'll tell you, it's not going to be an effective way of getting the court up to speed with the arguments. If you want to go ahead and make the argument, I'll listen to it. I'll try to process it. But and I think it was the first day of trial, I think I indicated to everybody that I don't believe it's appropriate for parties just to file something and assume everybody knows what's going on. So if the other party says I need a little bit of time, I'll give them a little bit of time. But until that point, particularly on a motion to eliminate, none of this gets discussed. So if I have to spend some time digesting it, or the state needs time to figure it out, and we get into opening statements and this has anything to do with opening, it's not going to be talked about because it's an issue before the court.
Well, I'm not sure I'm tracking. Here's the position I'm trying to state
Hold on a
to you.
second. How can you not try it? We received this at 8 o'clock in the morning. If this brings up issues that the court needs to digest and think about and work through, I'm going to do that. The state, literally, as I understand it, is now doing exactly the same thing. We plan to open tomorrow. We plan to get to opening statements tomorrow. If this is something, and I'm not suggesting it is, but I'm just telling everybody generally, if this is something that the court's going to have to take some time to work through, in addition to the arguments that have already been made by Mr. Sheffield in his motion, then I'm going to do that. And until I have done that, everyone must assume that the matter is under advisement and it won't be discussed.
Well, here's why I call it a courtesy. I didn't have to file this, and I could have done what I'm...
And I appreciate that courtesy, but this still would apply. If it's a brand new argument and everybody's got to work through it, then I've got to take the matter under advisement and work through it.
Well, I could easily just go ahead and withdraw this and do what I plan to do in opening statement when I hear the state do what I fully expect the state to do, because I will be on good grounds to do it, and I will do it. And if the state objects and the court needs to then take a recess and send the jury out and rule on it, that's okay. I just did this so you wouldn't have to do that.
I'm not sure how you became antagonistic on the court's. I'm simply saying if I get something at 8:09 in the morning and haven't had a chance to digest it, then... Well, I don't understand that, because you've also indicated you're willing to argue it. I'm willing to hear what you have to say. I'm simply telling you how I'm approaching it. I'm not suggesting you can't argue the matter, or that it's not
I thought you
before the
wanted
court.
to read it first.
If I may, it's a little bit after 11. We normally take our lunch break a little later, but...
Yeah, let's do this.
Oh, okay, all right, all right.
I'll argue, Your Honor, it's not very complicated. So, is the court ready to hear me argue it?
I'm here.
All right. All right, as I was saying, the state wrote in its motion in limine that they think that our intent to talk about Mr. Arbery's probationary status is to engage, and these are their words, to engage in speculation as to why Mr. Arbery acted as he did. Now, the act in question is his manner of locomotion, his running. The state has repeatedly throughout this case characterized that locomotion as running or jogging. Now, when you look at somebody in that act, you don't know why they're doing it. If you see a runner go past your window running, you have no idea what is motivating the person to run. It could be health, exercise, fun, or it could be fear or running from something or someone. The state has consistently taken the position, and I anticipate will do so starting tomorrow in their opening statement, that Mr. Arbery was an avid runner or jogger or both. Jogging, as we all know, is just a form of exercise engaged in by people who run at a moderate pace for health. And that's what, in fact, many of their witnesses on their witness list, as we've been able to uncover by talking to them, are prepared to come and testify to. Your Honor, if you want to read it, I'll stop talking. I don't think people can do both at the same time. I mean, I'd like to either have the court's full attention or stop and let you read.
You have the court's full attention.
Okay. I couldn't tell that I did. I see your moving pages.
Okay. Mr. Hogue, I'm not sure what you're trying to do here, but
I just want to make an argument to the court with your full attention.
okay, the court is listening to your argument. I am going through the brief that you filed so I can follow and pick up in the brief these arguments as you make them, so I can see what facts you're relying upon, what case law that you have, just to make sure that I'm clear about the argument. So to the extent that you are not having direct contact with the court eye to eye the entire time you're arguing, I apologize if you think that that is the court's inattention. But in fact, what I'm doing is what I do with just about everybody that's argued in front of me, which is, as you're moving through your argument, I am moving through my thoughts. I'm trying to figure out where the arguments are coming from, what citations you have out there. That's the court's process. You may be offended by the court's process, but that is the court's process. You can continue.
I'm not offended. I just know that when I'm talking to my wife and co-counsel and she's reading something, I will stop and let her finish reading so that she can listen to me. And I do the same for her as a courtesy to her. Because actually people can't do those two things at once.
Mr. Hogue, this is the second time you've suggested to the court that I'm not being courteous to you. I'm not sure what the issue is. I've explained what I'm doing. I don't think I need to explain any further other than to say this court is spending a lot of time working through issues presented by the state and the defense and doing everything that it can to ensure that this is a fair trial and that the issues that are presented are ruled upon to the best of my ability. And I will continue to do so in this case. If you wish to make your argument, you're welcome to do so, but we've spent a lot of time not on your argument in the last 15 minutes or so. I'm more than happy to hear the argument, read the brief, take it all into consideration as the court would normally do, and make a ruling.
I'm asking the court if it would do those two things one at a time. I mean, I don't mind sitting down if you want to read.
Listen, if you're going to abandon your argument, you can abandon it,
I don't
or you can
abandon
present
it.
your argument.
I'm not abandoning
Go
it.
ahead and present your argument.
All right. So, as I was saying, when a person is running and we see the person running, we have no idea why, what's motivating the person to run. The state has consistently in all pretrial motions and comments on this case, and I anticipate will do so again tomorrow in opening statement, and throughout the case when they call witnesses to talk about Mr. Arbery's penchant for running, will characterize that running as motivated by a desire for health, exercise, pleasure, and so forth. That is what they will inject into the case. Now, on February 23, 2020, that will be a speculation by the state concerning Mr. Arbery's motivation for running that day in that place. It's an inference they may draw from the other evidence they may try to present that he was an inveterate runner who ran all over the place all the time. They may even try to say that he ran in Satilla Shores regularly. I don't know that they'll have any evidence to support that. But at any rate, Your Honor, their point to this jury will be that when he was running in Satilla Shores on February 23, he was doing so for pleasure, exercise, etc. Now that is a speculative inference they've drawn and will continue to draw to the jury. Mr. Arbery's status on probation provides a reasonable alternative view, a reasonable alternative belief that can be formed, that we could argue, that says, well, they could be right. He may have been running there in Satilla Shores for exercise and pleasure, but let's tell you another explanation that's equally, if not more, reasonable. He's on probation. He's inside the English house. Matt Albenzi sees him in the house. All of this is on video and will be testified to. Matt Albenzi then picks up his cell phone and calls the police. And Mr. Arbery comes out of the house, sees him, Mr. Albenzi, and immediately turns to his right and runs at a sprint. 5 houses up the street is Mr. McMichael in his driveway, fixing boat cushions in the bed of his truck, using his truck bed as a workbench. Sees Mr. Arbery running past, and as we all know, Mr. McMichael's colorful expression for what he saw was that he was hauling ass. And he said he wasn't out for no Sunday jog. He was sprinting. He looked like a wide receiver. These are things he said as he noticed him. Now, obviously, he didn't know he was on probation, and we're not arguing, at least I'm not right here now, that Mr. Arbery's probationary status is relevant because Mr. McMichael knew it. He didn't know it. But when the state says he was running that day for pleasure, and Mr. McMichael sees a person running and he thinks he's running from something, being chased by someone, as he told the police that day, then a reasonable alternative explanation could be, well, Mr. Arbery's running because he's on probation. He's been spotted at the least trespassing. At the worst, back in a house he'd been in 4 previous times where burglaries had occurred, in a neighborhood where other burglaries and break-ins had occurred. And so when he was running at this sprint, not a Sunday jog, and continued to run until the end of this tragic scenario, a reasonable alternative explanation for that running could be, well, he's running because he's on probation. He sees a guy who's just had a cell phone to his ear, possibly calling the police, which in fact he was. And therefore, Mr. Arbery, who had had his probation revoked 2 times before, for which he'd spent time in the county jail, did not want to be caught trespassing or caught and interrogated for previous entries into that house where burglaries had occurred. And so when the state says, no, he's just out for a Sunday jog, we ought to be able to attempt to rebut that by offering an alternative explanation. It does not go to the mental state of the McMichaels, and I'm not arguing that it does. I'm arguing that it is an answer that the jury should have before it, so they can determine why he's running, not just because the state says he's out for a Sunday jog. Let the jury decide which it is. We want to be able to give this alternative explanation. That's the argument that's in this short motion, and I leave it there and tap out for Mr. Sheffield to take over.
Thank you, I concur with that. On behalf of Travis McMichael, essentially what we're talking about there is opening the door to the intent
Which
of
is
the running.
Covered here in the motion that
It is. Yeah, that's why it's a simple issue. I hate that we got sidetracked. And, Your Honor, we're going to continue to do our best to put issues in front of this thoughtful court in a way that gives the court time to wade through these tricky issues, because we really are dealing with the type of evidence that the rules of evidence say under 401 it's relevant, but the court well knows, the state has argued against it, that it can dip into 403 but still be admissible relevant evidence under 401. So we understand the court is walking a fine line and trying to interpret. In addition to opening the door that the state has done repeatedly, and we believe will do during trial on this issue of running, it is intrinsic, not in the minds of the McMichaels, but it is intrinsic that this young man is on probation and has been jailed for failure to adhere to probation conditions by committing new crimes and by not reporting, and has been punished for that. He is currently on probation at this time in 2 cases, and he has a long-standing relationship with the probation department for those failures. And so under the cases that we've cited, those courts note that when the defendant in that case, the one who's actually on trial and risking going to prison, the state was allowed to introduce evidence that the probation was there and relevant, because if he indeed, quote unquote, ran from the police because he was on probation, that showed his motive. So we do get back into the motive and the intent of Mr. Arbery, not as an extrinsic element, not as a 404B, but as an intrinsic element to his life and circumstances at the moment that he chose to run. Now, the video very clearly shows that Mr. Arbery did not run into the neighborhood. It very clearly shows that he walked into the neighborhood, that he stood in the front lawn, that he looked left, looked right, looked forward, looked backwards, and then went into this home. And when seen and observed by the neighbor, he is running out of that house at a rate that is more than just a jog. The evidence will also show that he was informed, in fact, that the police were on the way, and that created more running and turning. And so we feel that we have a substantial basis for the jury to learn that he is running to avoid being arrested. And those cases that we cite, I think, are very clear. So we join in the open the door, but we also feel this is intrinsic. And these cases, clearly, as used against defendants, make that type of evidence relevant. Thank you.
Final word from the state.
Thank you, Judge. That was quite a lot of speculation about what the state was going to argue in this case. An opening statement. Mr. Arbery was an avid jogger, and under the rules of evidence, especially OCGA 244406, habit and routine practice. Evidence of the habit of a person or the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with such habit or routine practice. So, Mr. Arbery being seen by people who live in Fancy Bluff running indicates that he's an avid runner. In addition, the state has no intention of putting in that he was only running for his health, only running because it was good for him, or anything along those lines. We actually have evidence in this case that was put forth through Larry English's testimony on December 17th. The third video from Mr. Arbery going into the Larry English open, unsecured construction site is that Mr. Arbery steps outside, and you know what he does? He runs, and he runs away, and he runs onto the street and out of the frame. So there's actual evidence that when he was in 220 Satilla Drive, that when he left after staying there a few minutes, he ran away into the neighborhood, the exact same path that he took on February 23rd, 2020. And that has already been and will be testified to by Larry English. So the defense appears with this probation argument to try and go and skirt the court's order about the 404B evidence in a way that is speculative as to what Mr. Arbery was thinking, because this whole argument that we want to present an alternative reason for him to run away, Judge, I fully expect the defense to argue, yeah, he got spotted by Albenze, he was committing a crime, they'll figure out what that crime is and tell the jury, I guess, and that he was running away because 911 was on the way, because he has ESP and can tell that Albenze is not on the phone with somebody else, but is on the phone with 911, and that he took off running. I'm sure they're going to argue that. And the fact that Greg McMichael didn't know any of that, that Travis McMichael was inside that house on his sofa, that Mr. Bryan, at the time that this all took place, was fixing the front of his house, makes it completely irrelevant as to why he was running down the street. Greg McMichael's words say it all. I saw him run down the street, he was hauling ass. And that's all the McMichaels knew. So what was, again, in Mr. Arbery's mind when he did this is completely irrelevant to Greg McMichael running inside his house, getting his son, getting his gun, and getting that shotgun and getting in that truck and chasing after him. Because what Mr. Arbery was thinking at the moment he saw Mr. Albenze, they didn't even know that took place. So this appears to be, from the state's position, just a backdoor way to try and impugn his character and go from there. Yes, he was on probation in 2 cases. Those 2 cases and all that information has been excluded as not relevant. In addition, the cases that they're citing to are obstruction cases. Okay, in obstruction cases, when I see an officer who's in uniform, okay, I'm on probation, I can tell this guy may or may not arrest me. He's a law enforcement officer coming at me. So when I run from him and charged with obstruction, of course it's relevant for the state to go, well, the reason he was running, he was on probation, he saw a law enforcement officer. So it's an obstruction case. So it doesn't really apply here, especially since the defendants had no knowledge. And once again, it's speculation as to what was going through Mr. Arbery's head. We ask that you, I'm trying to call it, my motions, I ask that you grant my motion to prohibit them from going into the probation. Thank you, Judge.
Very briefly, Your Honor.
So much for the court's instruction.
Well, if I may just respond briefly, I won't be long. Much of what the state just said, we don't disagree with. The fact that Mr. Arbery was an avid jogger, for example, that it was a habit and routine, for example. But what relevance is that to our case, that he had the habit of running, if not to make the inference that the state wishes to make, that that is what he was doing in Satilla Shores that day. That is what they want to do. And so the example of December 17th to support the habit theory that he's in the house and he jogs or runs away, well, it was at night. Nobody was there. He's on a camera that he doesn't even know is there, perhaps, and no one has seen him. The difference is what I described earlier that happened on the broad daylight of 2/23/20. So I just want to focus the open the door argument. The other argument I'll leave with Mr. Sheffield, but the open the door argument is that if they want to bring in witnesses to say he was an inveterate runner and that was his habit, that's fine, but that opens the door to other reasonable explanations for why he was running on that occasion. Because it's true that one can run on a given day or even at a given hour of the day for exercise, and then run on another day or another hour of the same day out of fear of being caught because he's on probation trespassing. Both of those can be true. And so it's not responsive to this argument I've made here just say that, well, he's an inveterate runner and we've got witnesses to say he ran all the time. Fine. But it's the inference they want to make that we want to be able to answer for the jury by rebutting it.
All right. Court's going to take the matter under advisement. I'll get a ruling out prior to opening statements. The last thing I had on the state side, 4.72 is a brief on character witnesses and opening the door to character evidence. I'm just going to take that under advisement. It's a brief. I think I've gotten something similar back from the defense. There was a, recently, I think, I just haven't had an opportunity to fully digest it yet, but something came back about opening the door from the defense.
Well, Your Honor, if I may, I was handed by my colleagues, and I think this is, we never titled what the brief was that we got at 8:09 this morning. I received something that I didn't receive it. I mean, probably got it in my email, but at 8:09 I was here. So, defendant's motion for the admission of evidence pertaining to Ahmaud Arbery if the state opens the door at trial to the admission of such evidence.
I didn't read the title, but that is addressed to the probation matter. That was just argued.
Well, we used that motion, I believe, to address that issue, but there are other issues that we believe become relevant, Judge, under the umbrella of open the door. And the state...
There was actually a really good article, I think, recently. It was the Georgia Bar Journal or something that talked about litigation by motion in limine.
Cobb County judge, I believe.
Was it Cobb County?
Judge Manning.
Yeah, it was a fine jurist then out of Cobb County. I'm not going to do that. This whole idea of opening the door, I'm not going to prejudge the evidence that's coming in order to make a determination on opening the door and under what particular circumstances the door could possibly be opened. I'm not going to do that. Okay. I mean, I understand that the arguments may be presented that the door has been opened on something. I would suggest that if the door is currently closed, before you walk through it, we have a discussion with the court on that.
Okay.
But I've got these competing motions back and forth that start addressing these topics. And again, I don't think motions in limine are the appropriate time to do that.
And, Your Honor, if I may, that brief from the state was simply a way to keep everybody informed on what the state believes the law and the position of the law is, and to inform the court about the state's intention. The reason I did that is for what's happening here today. The defense has repeatedly told this court the state's doing this, the state's saying this, the state's going to do this, the state's going to do that. And I feel that I have not been able to adequately respond. So in this case, I did want to at least respond in writing to give the court what the state's intention with these witnesses was and to provide some law, and so that I could rely on that if it became an issue. And that was all I wanted to do, and I understand that this is a response to that. Now, my question, I guess, on this, the defendant's motion for the admission of evidence pertaining to Ahmaud Arbery if the state opens the door at trial to the admission of such evidence. Mr. Hogue, was that the brief that you were standing up here arguing and talking to the court about?
I did part of it.
Yeah. Okay. I just wanted to make sure I was on the same page. You didn't say the title, so I did not know, and I wanted to make sure I was looking at the same thing everyone else was looking at. So if that was it, then it's fine. And that is all that is. There's no need to argue it. Thank you, Judge.
Your Honor, for the sake of the record, we discussed it at the beginning of the first motion that we were taking up today about the use of force expert. We want to make clear we had adopted that motion. As to the motion regarding the THC, we wanted to adopt the motion that the McMichaels pursued, join in on that. And third, I think the one that's currently before the court is the probationary status in one way or another. We also want to adopt that. And I'm going to confer with co-counsel on if we have a lunch recess before the court rules, because I don't understand, maybe I missed it or was not paying attention, but there seems to be some case law fairly directly on point on this subject, which no one's discussed this morning. So I want to confer with them about that, and if there's something to bring to the court, we will.
Thank you. All right. Based on my notes, then, we move into the McMichaels outstanding motions. First one I have that is still before the court. Let's see if I can get my numbering is right here. Looks like I've got, and it's actually couched as a motion associated with voir dire, but it looks like 5.7 is the motion to eliminate all doubt and a mathematical certainty language from the jury charge on reasonable doubt. I've got, why don't I go through and tell you what I have as open. I've got that. I have a motion regarding the vanity plate, a motion regarding Officer Duggan, hopefully I'm pronouncing that correctly, body cam, and the motion to seat all jurors in the jury box during the trial. Those appear to be the open McMichael's motions.
Your Honor, if I may, I think part of the big pot of State's 4.64, which is the State's motion in limine for a pre-charge jury, a pre-charge to the jury, and I believe then we had defendants 5.6, which was the defendant's response to the court's inquiry regarding a preliminary jury instruction. That was filed on September 1st by the defense. The state filed a response September 2nd, and that's part of the pot that I think goes with 5.7.
Okay, that makes sense. I'm just trying to track it. And maybe I skipped over it because I drafted a pre-charge, which I can get to everybody this morning. I just need to print it out and get copies of it to everybody, which included the requests for basic, and I use that term intentionally, pre-charges on certain aspects of the law that I understood from reading those submissions, everybody had agreed they wanted a pre-charge on. So I've got that. I'll go ahead and get it. I'll get everybody a copy of that before lunch. Maybe we can address all of this then after lunch, once everybody's had an opportunity to review the pre-charge.
Yes, and that is my memory of how we did it. The state moved for pre-charge. You said, well, let's all just hear what we want in that, and then you'll consolidate it and make those decisions.
Yeah.
The only part of that that might be a little bit different is the 5.7 with respect to the reasonable doubt standard in the pre-charge as well as the final charge. So that might be one issue to litigate before we take a look at the...
Why don't we, it sounds like we can put the cart before the horse. I'll get you the pre-charge, and you can look at the language that the court is using. That language still appears in the pre-charge, so we still do need to argue it, but we can do that once the entire pre-charge has been reviewed, and we can just take it all up at one time.
Very good.
Okay.
Thank you, Judge.
So then I have the motion in limine regarding the vanity plate.
Do you want to do that now, Your Honor?
You know what time is it? 11:44.
Mr. Sheffield, and he thought we were doing the mathematical doubt and just stepped out.
Just stepped out.
That's it.
I was going to say, then we got the body cam, and well, why don't we go ahead and address the motion then with regard to the jury box?
Your Honor, do you know if that big TV right there is connected to the internet? And if so, I could pull up the current, as of right now, Glenn County. I've got the internet address in this motion, but I looked at it on my computer this morning, and the numbers have gotten even better. I see it.
Are you talking about the coastal health district numbers?
Let me.
I can pull up the coastal health district.
Yeah,
numbers.
if you can pull them up for yourself.
I check them every day.
It's the COVID. Let me make sure it's the COVID-19.gachd.org.
Yeah, I've got
It's
the
that
coastal health district
website.
information as well as the state DPH information, which dovetails in.
Well, I just looked this morning, and my brief's already a little bit out of date. The numbers are even better today. I got the numbers up through November 3rd, which is
There's
yesterday.
been a uniform downward trend, which we had all hoped for given the nature of the case
Yes.
and the number of folks that we had coming in.
Well, so if you're ready for me to argue this, I will. In brief, the remedy we're seeking here is to have the jurors seated here in the jury box. 2, 4, 6, 8, 10, 12. There's 14, so we'd have to have 2 others outside the jury box, I guess. I won't repeat all the details that are in this brief concerning the importance of having a jury in the jury box. I think that's just something we all know well from being in court so many times over the years. As a practical matter, obviously, it would be so much better for all the lawyers, and I hope the state may ultimately agree with me. It would be nice that we all would like to have our jury right here, and we can just do our thing here in the well of the court like we are so accustomed to doing. So the way I see it, Your Honor, is that what we're doing is trying to balance 2 competing interests here. As many decisions in life are, they're a balancing test, and on the one side of the scale we have the defendant's rights under the U.S. Constitution and the Georgia Constitution. 5th, 6th, and 14th apply to the states for due process, the due process clause of the 14th Amendment itself, as well as the Georgia Constitution, Article 1, Section 1, paragraphs 1 and 2, regarding due process and a fair trial. On the other side of the scale, what we have in the balance is the health of the public, the health of these jurors in particular. And I acknowledge that to be a significant concern in this balancing test. And so the other part of the brief is addressing the current downward trend, fortunately, in COVID numbers here in Glenn County, suggesting that the scales could be tipping by now here in early November in favor of the constitutional rights of the defendants and the diminishing concerns for health risks to our jury. And I know that we have been here now almost 3 weeks with many people seated in the courtroom, many of us close together, not social distanced, not wearing masks even. Most of the lawyers and the defendants have not worn masks. Jurors could obviously wear masks if they're seated next to each other, and that would give them some protection. They would be closer than 6 feet, but they would have masks on if they chose to. I do note that yesterday when the jury was called into the courtroom to be told they're our jury, 5 of them did not have masks on. They were social distanced, of course, but they had chosen not to wear masks. And I think that should be left to their choice, unless the court ordered them to wear them, because if they were to be seated shoulder to shoulder in the jury box. So if the court's checking those numbers on the website, the court will see that they're going down, and that's good. In fact, we're down below, we're at 3.9 cases now, and as of yesterday, I think when I wrote the motion, it was at 4.7 cases for a 7-day rolling average, and 3.9 now is getting way down there low. I mean, we're in the area where it's getting just safer and safer to walk around and be in closed places like a courthouse for days at a time. Anecdotally, and I put this in the brief too, as the court knows, because of the scheduling issues that this court got involved in with another judge who presided over a death penalty case, I tried recently. I went to Grady County in late August the 24th, 2021, to start jury selection in a death penalty case. And we were in Grady County for 3 weeks selecting a jury up until mid-September. unlike you, Your Honor, the judge in that case never expected or required anyone to take any COVID precautions. It was very concerning to me, and I moved to continue that case many times because of that. And finally, we got that case to trial. And for 3 weeks in Grady County, where the numbers were many times higher then in August than they are here in Glenn County right now, we had jurors 60 at a time. I hear that too. And my hearing's not even very good.
Sound like a radio outside the courtroom.
So we were in a courtroom where it was a large gallery area, and our judge called 60 jurors at a time and had them seated right next to each other in theater-like seats, and then broke them off into panels for us to do, like we've done here. We did general voir dire, and then we did individual voir dire, very similar to what we've just experienced here for 2.5 weeks. And over the course of that time, no one was social distanced. The courtroom was packed. Hardly anybody wore a mask. It was a bit bizarre, but we didn't lose any jurors to COVID. It was kind of amazing to me. We went back to Putnam County. We tried the case for 2 more weeks with these jurors seated in a jury box like this next to each other, and only 3 of them wore a mask. Witnesses came in and testified. It was a 2-week-long trial, and to my knowledge, and I've not received any reports to the contrary, amazingly, nobody got COVID. So I say that as an anecdote. Obviously, that's not evidence of what would happen here. I mean, somebody could get COVID here. Somebody could have it right now. But because of the diminishing numbers and the importance of trying this case in a normal fashion, I'd like to note, too, that if we have jurors seated back here behind us, where I see those numbers on the benches, and then we have family over here, family of the defendants, family of Mr. Arbery, and I think you had media on a row, and who else? There was one other row of people, whoever. That side, I suppose, would be filled with people shoulder to shoulder, while the jurors are the only ones that would be social distanced. So I just don't know how much difference that's going to make in our fight against the transmission of COVID. There's my argument, Your Honor.
May I just add to what Mr. Hoke said, not repeat what he said, which he said, well, and I kind of assume the court's thought all of this through because you've been inundated with this public health information for a long time now. So I know you're thoughtfully considering all the options in the case on this issue. The 2 concerns with the way it's set up, or 3 concerns really. In opening statement tomorrow, I'm giving opening statement from Travis McMichael. I'm going to have to address both the jury here and the jurors back there the way it's set up, which means literally talking over the state's head, which is...
Won't be sitting right there.
Won't be there. Okay, so that's obviously we're missing some information here. The other concern and a bigger concern is...
Well, and just to be clear, we're shifting a table because there's a number of issues there. One is potential sightlines. 2 would be your ability to use the area as well and address the entire panel. And 3, anything that's on the state's table doesn't need to be seen by the jury. So that table is going to be shifted to address all 3 of those issues.
Thank you, because that addresses my other concern, which is the way the jury is seated now, and Ms. Donikoski and I talked about this, numbers 5 and 6 can see our computers. And not to mention people in the gallery, the press, the families can see our computers, and that's a real concern. And
that would be the case whether the jury was sitting there or not. There's always going to be people in the gallery behind. I'll go ahead and take a look at 5 and 6, though, and try to work through that.
Typically, though, in probably every case I've tried, the decedent's family is not sitting behind the defense side, they're on the prosecution side. And so we don't have that concern. I mean, it's another point of concern, plus the fact that they're seated shoulder to shoulder with what that does for the spread of COVID, if any concern at all. So these are additional concerns to what Mr. Hogue raised, and I would ask the court, or I would join the motion, ask the court to seat the jury in the box.
Anything from Mr. Shaw?
Your Honor, our concern, we very much appreciate the thought that's gone into the motion. Our primary concern is about the masks. Our contention is under the 5th, 6th, and 14th Amendments to the United States Constitution, the parallel provisions of the Georgia Constitution, that the defendant is entitled, and his counsel are entitled to be able to see the faces of the jurors during the trial. It's important that we have that ability. Part of what lawyers do during a trial is they try and assess the feedback, the nonverbal communication from the jurors during the jury trial process. It's been the way it's been since the foundation of this republic. Given the compelling health evidence that Mr. Hogue has presented to the court, our contention is whether we seat the 14 or 16 up there in the box, or we seat them as currently planned, we believe that we're entitled to have a jury that is not masked. And to the extent it impacts that process, and I know the court is dealing with, I don't know, probably maybe unprecedented to me at least, logistics issues and geography issues in the courtroom, and I appreciate that. But under the existing seating arrangement, the jurors can be socially distanced, and I was hoping that the court was doing that so that they would not need to wear masks. If they're going to be wearing masks, then we certainly think there's no reason not to put them all in the jury box. Because if they have to wear masks anyway, we might as well have them where we can all see them and not have this complication in terms of the presentation of the evidence. But our primary concern here, more so than the seating arrangements for the jurors, I'm curious about this table arrangement. So I'm not sure how that impacts us over here, but you'll tell us at a suitable time. But I am concerned that constitutionally, I think we have a constitutional right to be able to see the jurors in the jury room as the evidence is presented, to see them as we give our opening arguments and our closing statements so that we can see how they're reacting. If you're making an argument to the jury and everybody's kind of looking down or shaking their head no, or they're laughing when they're not supposed, smiling when they're not supposed to be laughing, then it's kind of a hint to counsel and maybe we should move on to something else. We are deprived of that nonverbal feedback when we mask the jurors. So that is our primary concern, and that is not a matter of convenience to the parties, that is a constitutional right.
One other concern that
I failed to raise, and that is that, obviously, any case like this, and maybe especially this case, is very emotional. And the proximity of jurors to the family members on both sides is going to be difficult, maybe influential, inadvertently. We would expect, as it's been so far, that we feel the emotion in the courtroom. We would expect it's going to only be raised during the course and presentation of evidence during the course of trial. And so we think that is also going to be difficult for the jurors to put that aside, and may in fact create problems down the road, which we would all want to avoid. Thank you, Judge.
Anything from the state on the matter?
No, Your Honor, we leave it to the discretion of the court.
Right, I thought the state was going to agree.
Well, the state doesn't oppose it, if that's what you're asking. The state does not oppose sitting the jurors in the box. Obviously, these are benches. Those are much more comfortable seats. I have no idea if the court will seek input from the jurors themselves. The state's vaccinated, so I have no idea how many jurors are vaccinated. I have no idea how many would want to wear a mask, want to be socially distanced. We don't know how many want to be in the more comfortable chairs. These are all things that can be considered, but The state does not oppose the motion.
Okay. A couple things. First of all, the setup of the court is actually the setup that was part of the Glenn County jury resumption plan. This particular setup has been used, I know, by Judge Scarlett in the adjoining courtroom, which is an exact mirror of this courtroom. And that's how cases have been tried in that courtroom. I'm not sure if Judge Kelly, I assume Judge Kelly's probably tried some cases in this courtroom, but I don't know. But I know that the exact setup has been used in Glenn County for jury trials, including, I would imagine, some significant felony cases. So we're consistent with that, from what I understand. Okay, again, I'm here from a different circuit, and so I'm adopting this circuit's plan, and this is where we are. I have reviewed the plan, or reviewed the setup, and tried to work through exactly what some of the issues are, and we're still, well, I think we're most of the way there. This juror 5 and 6 issue is something I appreciate counsel brought up. I need to work through that. But the bottom line on the changes, first of all, CDC guidelines are still in place. What may have happened, and Mr. O said this, it's anecdotal, what may have been done in Putnam County, that's up to that particular jurisdiction to determine how to handle what they do, their business, and their particular approach to cases. But CDC guidelines are still in place. I think it's important, and important enough where the Supreme Court, when the Supreme Court was issuing its emergency orders, pointed out a number of times, we've got a unique set of circumstances when it comes to jurors. When we suspended jury trials, part of the calculus in that was that when we have jury trials, we are compelling members of the public to do their public service. We are not asking, we're not inviting, we are ordering people, a cross-section of the community, to come into the courthouse and do what we ask them to do, which is sit as a panel and listen to the evidence. In order to do that, they need to be comfortable. In order to do that, they need to be able to sit wherever they're sitting and listen to the evidence without in the back of their mind thinking, oh, that person next to me who is shoulder to shoulder just coughed. And I just use that as an example. There are other examples I could come up with. And so the reason that this court plans to adhere to social distancing at this point is, one, CDC guidelines are still in place. The jury plan was enacted in this circuit and has been used. We are compelling these jurors to be here for an extended period of time. What the rest of the public does in this courtroom and what you do in this courtroom, I have not gotten involved with, because I'm not, other than the fact we're having the case and I'm telling you when to be here, it's very different from how a juror is appearing, the members of the public that are here, the media that are here. I'm not ordering them to be here. If they want to sit in this courtroom under the restrictions and the circumstances that we have, that's up to them, but that does not apply to the jury. And the court has to take that into consideration. And the jury is a significant, if not a priority for the court, to ensure that they are able to do the very important work that they are doing without distraction. So that is why we are here. As to the numbers, I agree they're coming down, but the transmission index, we can pick out whatever we want from CDC. But in my discussions with the Public Health Department, it was suggested that the transmission index is probably one of the best indicators of where we are. And because the numbers are trending downwards, that transmission index is getting lower, but it's creeping lower. It's still in the moderately high category for Glenn County. Glenn County was ravaged with COVID no more than a month, 6 weeks ago. Those numbers were extraordinarily high in this community. And so I can't imagine it's still not at least a concern to some that are coming into this courthouse. So I say all that because there are other things that I'm going to look at based on what was discussed, mentioned. I guess it wasn't really a discussion. It's more of a presentation presented here. I'll consider the motion, but based on where the numbers are currently, the jury plan and the CDC guidelines, I have not seen any evidence that this court should deviate away from the circuit plan at this point. We may modify a few things, again, based on some of the comments made.
Just for the sake of the record, I very much appreciate the thoughtfulness of the court in all of this. The three courtrooms are close, but I would not agree to be on the record that they're identical.
It's effectively a mirror of what we've got here.
Well, I can remember, for example, at least for some years, if not still to this day, the witness chair in one of these courtrooms, the original courtroom for Judge Williams, sits ahead of its original location because an issue came up as to the ability of the counsel and the attorneys to see the witness in the witness box. And I'll just see you. There's a history here. We also have historically had issues as to whether counsel or defendants can see the witness, sometimes I think it was a witness, in the jury box. I can remember in the middle of a trial with an especially short client, shorter I believe than Mr. Bryan, sitting in here having my investigator take measurements and put them in the record. So I wouldn't be, I'm just cautioning the court, I wouldn't be so quick to rely on the fact that because other people and other judges in Glenn County have conducted court in these facilities that you should necessarily assume that meets all constitutional or other requirements. Because that has been an issue at times in the past.
I didn't say that. I just said that they were trying cases consistent with the circuit jury plan. I know Judge Scarlett's tried cases over there. In fact, he's got plexiglass up. So there's even more protection. Well, we could debate what plexiglass does, but there is more outward signs of protection in his courtroom. And my point was simply it's a mirror. It's a similar setup. So I'll continue to work through this probably up to the point that the jury is impaneled and probably even through the trial itself, just to make sure that we are doing this appropriately and effectively given the unprecedented circumstances that we are trying the case with regard to the public health issues that this community has experienced.
Judge, we did begin to discuss with the Sheriff's Department this morning, albeit not at the highest level, but whether there would be, as an option, as we're working through this, some kind of a barrier.
I heard that as an idea, and just hearing it and processing it, I understand it. It makes a bit of sense. How effectively and efficiently that can be addressed, there's other things I need to check on.
I'm willing to help build whatever it is.
Okay. All right, it's probably a good time to break for lunch. Let's see, it is 12:09. Let's plan on rejoining at 1:15. If y'all could give me a moment to print out the preliminary charge, and then you're welcome to come back maybe 5 minutes or so and grab a copy of the preliminary charge.
Yes, Your Honor, and one of the things that Mr. Sheffield and I had discussed in regard to defendant's motion in limine regarding Officer Duggan's body cam video, I have prepared a jump drive with that video on it, and I think both parties agree that it might be more prudent it's only 7 minutes long, and the front part is about 3 minutes long, that I believe is the part of contention. If the court wishes to look at it in camera, because of course the court's going to have, us describing it isn't going to do the court any good. So I wanted to put on the record, and that was handing you a jump drive that has Officer Duggan's body cam video on it for an in-camera review. Is that correct, Mr. Rubin, Mr. Sheffield?
That's correct.
Yes, Your Honor.
Just a thought before we adjourn for lunch?
Well, I'm making sure there's consent that the court review the video and camera.
Yes.
Okay. And I have been handed a jump drive, and that's the only thing on the jump drive.
The only thing on the jump drive.
I think the court will agree that a lot of progress has been made this morning on the remaining matters before the court. We haven't even really begun to discuss the charge issues. I'm just throwing it out there for the possibility to consider whether we might inform the jurors that we might want them at, say, 11 or 12 o'clock tomorrow for their opening statements, because I just have a feeling that we're not going to get through everything we want to this afternoon. But I'm just throwing that out there because I know the look I'm going to get if I come up at 4 o'clock and say, now it's time to call the jurors. Just for what it's worth. Putting them back a little bit would also give counsel, and I think Ms. Dunikowski might share in that desire, to have a little more time to be ready to do the opening statements adjusted to the court's rulings this afternoon on what's the law. Oh, I stand corrected.
I fall into this same category back when I was on the other side of this bench. What I have found, Mr. Goff, is if we give everybody 4 hours, we'll take 6. If we give everybody 6 hours, we'll take 8. I'm not going to limit, I'm going to see how much we can get through today. I'm cautiously optimistic that we'll be able to address what needs to be addressed today.
You know me, Your Honor, I'm always a pessimist.
So I said I'm cautiously optimistic. All right, let's go ahead and we will be in recess until 1:15.